Hello viewer, very good morning to all of you. This is Sandeep Kumar from Sandeep IAS Academy. I am a motivational speaker, writer in UPSC faculty. Today I am going to discuss one article from Current Affairs. This article is related with judiciary. So we shall discuss about the organization, structure and functioning of the judiciary. Viewer, before explaining the article, I would like to narrate one beautiful story which took place between Justice T.S. Thakur and lawyer Nazim Waziri. So after the conclusion of the matter, Justice T.S. Thakur, who was the judge of Delhi High Court, after conclusion of the matter, Justice T.S. Thakur had given longest date and he was heading for the lunch. And then something interesting happened. When Justice T.S. Thakur was heading for the lunch, then the lawyer Nazim Waziri recited wonderful poem of Ghalib and he said, "Kaun jeeta hai tere julf ke sar hone tak," means I am not going to wait that long for you to respond. Thakur sir was leaving and he came back to his seat and sat down and said, "Pehla misra padhiye zara." Then Mr. Waziri said, "Ah ko chahiye ek umr asar hone tak." Ah ko chahiye ek umr asar hone tak means it takes a long time for the wishes of a lover to be acknowledged by the beloved. And Thakur sir was so impressed that he gave him a date in the next week. So dear viewer, now I am coming directly to the article. The article is all about whether All India Judicial Services should be established or not. So this debate has been going on from the past many years, and right now the government of India or central government is taking some right decision in the establishment of All India Judicial Services. In 2019, the central government started consultative process, and this consultative process was supported by 4 states and 2 high courts. Means this consultative process was all about establishment of All India Judicial Services, and then 4 state and 2 high court has very categorically supported this initiative. 8 states has completely rejected it, 5 states suggested some changes, and 11 states are yet to respond. So this is the initiative which are being taken by the government of India. And then moreover, government of India has abolished many tribunals. Government of India is abolishing many tribunals. It means government is very much positive about establishment of All India Judicial Services. And moreover, the government of India has also changed the rule of game. Means the process by which the members are appointed in the tribunal, that process has also altered. Government of India has changed that process. Means the various rules and regulation has been changed by the government of India, by which the members are appointed in the tribunal. The next point is whether establishment of All India Judicial Services is constitutionally valid or not. So this point is based upon the 3 basic things. The first one is Article 233 Clause 1. Second one is Article 312 Clause 1. And third one is about the 7th schedule. So Article 233 Clause 1 says that it is the responsibility of the governor to appoint district judge after consultation with the High Court. As far as Article 312 is concerned, it is the responsibility of the Union government to create All India Services and All India Judicial Services. As far as 7th schedule is concerned, there is a very interesting story. In 7th schedule, these 2 things, Article 312 Clause 1 and 7th schedule, both comes under the 42nd Amendment Act 1976. So Article 312 Clause 1 is giving the power or is giving the autonomy to the Union government to create All India Civil Services along with the All India Judicial Services for any state along with union. As far as 7th schedule is concerned, in the 7th schedule there are the 3 lists: state list, union list, concurrent list. So the first list is the union list, second list is the state list, and third list is the concurrent list. So the judiciary matter has been transferred from a state list to the concurrent list. It means earlier it was the part of state, except High Court and Supreme Court. State was having the autonomy to frame the rules related with judiciary except High Court and Supreme Court. But later on this subject was transferred from state list to the concurrent list. And so in the concurrent list, both state as well as union, means central government, is having authority to frame the rules. But in case of conflict of interest, in case of ideological differences, the central government will prevail. It means it's a very simple that through the route of 7th schedule, the union government is having the full autonomy to frame the rules related with the judiciary. It means the union government is having more power to establish all India judicial. As far as various issues are concerned, there is a dichotomy between the Article 233 and 312. Article 233 gives the power to the governor of the state to appointment of district judge after the consultation with the High Court, whereas Article 312 Clause 1 gives the responsibility to the union government about the establishment of all India civil services along with all India judicial services. As far as second issue is concerned, it's all about the language barrier. Suppose that if one person is transferred from Punjab, if someone is there who is hailing from Punjab, and if he is transferred to the Tamil Nadu or to the Kerala state, then he will face a very difficult situation in comprehending the local language, because as per the CRPC and CPC, in any district they can use their local language in communication process. But this is not going to become a very big issue in my perspective, because this is the same thing which is there in the all India civil services also. But there are many persons who are transferred from one state to another state as a district commissioner, as a district collector, and as a district magistrate, and they are doing a wonderful job. So this issue is not going to become a very great obstacle or great hurdle in the complete process. As far as the third issue is concerned, it's about the cultural issues. Cultural issues means there are the various local laws which are very much prevalent in that particular area. So if somebody is hailing from the different state and he is entering into that particular state, then he will have to cope up with that particular laws and with that particular culture. Even though it is also possible, and it can be countered with the same argument which I given you earlier, that civil servants are moving from one place to another place, so it's not a very great issue. Dear friends, as far as all India judicial services is concerned, it is favored by the various eminent bodies. The first National Judicial Pay Commission report advocated about the establishment of all India judicial services. In 1960, there was one conference called Chief Justice Conference. So Chief Justice Conference also advocated about the establishment of all India judicial services. As far as 14th Law Commission report is concerned, 14th Law Commission report is also having so much positives about the establishment of all India judicial services. As far as Supreme Court views is concerned, Supreme Court's views are concerned, there are the two cases. The first one is all judges cases which took place in 1992, and all judges association versus Union of India which took place in 2002. In these two cases, Supreme Court has also said very categorically about the establishment of all India judicial services. So in conclusion, we can say that union government should take the consent from each and every stakeholders, or rather I will say that union government should consult from each and every state, and after taking their decisions, after taking their concerns, after taking the various grievances by the various states, union government should frame such law which should be applicable to length and breadth of the country, and that must be beneficial for rest of the masses. Thank you so much.